Good morning, everybody, and thank you for joining us this morning on our third and final social housing webinar for our spring series. This morning's webinar is on common pitfalls in development agreements for registered social landlords. To introduce who's speaking this morning, well, for those of you that don't know me, my name is Fiona McLeod. I'm a legal director and solicitor advocate. I sit within our disputes practice and I have a particular expertise in advising housing providers on litigation and regulatory matters. I'm not doing any of the speaking though this morning. I'm joined this morning by my colleagues Kirsteen Milne and Claire Mills. Kirsteen Milne is a partner in our construction, infrastructure and projects team. Kirsteen works with clients from the outset of projects, from producing procurement strategies through implementation and on to completion, and she regularly provides advice on risk management at all stages of the construction process. Kirsteen is joined by Claire, and Claire's a legal director in our construction, infrastructure and projects team, and she also advises clients on procurement strategies, all forms of construction contracts and ancillary documentation. Claire acts for a number of house building contractors, as well as RSLs and local authorities, which gives her a well-rounded view of the market within this sector. So Kirsteen, Claire, over to you, and I'll come back at the end.
Thanks, Fiona. So this morning, Claire and I are going to consider a few topics, and we've grouped these together under the heading Common Pitfalls in Construction Contracts. And it is a bit of a mixture of topics, but we thought these would have particular relevance to parties procuring social housing, although some of the points might also be of general application to those procuring construction projects. I'm afraid it's not necessarily particularly groundbreaking stuff, but hopefully it is a useful refresher of things to think about. In the previous webinar in the series, Jenna and Elaine considered what to do if the developer you've contracted with has become insolvent. And whilst the focus of that was on arrangements with the administrator, etc., I know that remedies under the construction package were also considered. And the potential insolvency of a contractor is one of the driving forces behind many decisions that are made when agreeing construction contracts and development agreements, particularly when considering what performance security may be required. It's probably the insolvency of the Stuart Milne Group that's still fresh in people's memories, but there are many examples of construction companies, large and small, becoming insolvent. And in the year to February 2024, the total number of construction firms becoming insolvent was over 4,000, an average of over 12 companies a day. So it is important to ensure that there are appropriate contracts in place. So this morning, we're going to consider framework agreements, the pros and cons of those, why enter into a formal contract, potential issues when contracting using a development agreement rather than a building contract, and performance security and related measures to provide protection in the event of contractor and developer insolvency. But first, framework agreements. Now, this might not seem as related to the other topics, but we're aware that often these are used by public sector organisations when procuring works. And there are a few things to be considered when deciding whether to procure works directly or using a framework agreement, and a few things to watch out for. And for clarity, when I'm speaking about a framework agreement, I'm referring to an agreement that sets out terms and conditions of contracts that may be awarded to suppliers who are signed up to the framework during the lifetime of that framework agreement, usually 3 to 4 years. And if the procurement regulations in Scotland or England apply, then the maximum duration, other than in exceptional circumstances, will be 4 years for the framework. The framework agreement will set out the process for the contracts being awarded, usually named call-offs. That may be by mini competition, where several suppliers are asked to submit a bid, or the framework may allow a direct award in certain circumstances. And there may be mixtures of the two processes. So for example, a direct award for contracts under a certain value, or provided that certain conditions are met. If a party has decided to use a framework, perhaps due to the advantages we're going to be considering, they may have a choice of using a general framework that's been created by an organisation for use by many organisations, or they may choose to set up their own framework. We see both of these options being used, and when considering the pros and cons of frameworks, I'll try and distinguish between these. There are an abundance of framework agreements to be found in the market at the moment. From a very quick Google search, if I was a public sector client, I could potentially have access to at least 5 or 6 frameworks for construction works and consultant services across various lots. And that number doesn't include the large frameworks that are in place for specific sectors. Some of these frameworks are actually also accessible to private organisations. Whilst I've been unable to find statistics in relation to the percentage of contracts that are let under the framework, as opposed to being tendered separately, our experience is these are very prevalent in the market, and this use shows no signs of subsiding. So I'll just spend the next few minutes considering the benefits and drawbacks of these, taking into account, as I said, both those that are specialist framework organisations as well as bespoke ones set up by individual clients. So firstly, what are the advantages? Well, the cynics out there might say that the main reason for public sector bodies using frameworks is to avoid the public procurement regulations. A procurement process that is compliant with the regulations, either because the works exceed the regulation threshold or perhaps exceed an organisation's own internal threshold, which is often lower, can be seen by some to incur unnecessary expense and be time-consuming, delaying matters when people are just keen to proceed with the works if they've got the necessary funding or budgets in place. There is obviously a time advantage if the terms and conditions have been pre-agreed and all that's required is a mini competition or potentially, in some cases, a direct award to select the supplier that offers the best value for that particular project. And this reduced process and reduced negotiation will mean that there's a saving in costs incurred by the supplier as well in terms of bid costs, as well as by the client. There is also the potential for continuous improvement within a long-term relationship, as parties can reflect and use the learning from experience of the previous projects to improve the service for future projects. Key performance indicators can be used throughout a contract to monitor performance, and successive projects can be compared, and that should also assist public sector organisations to verify that public money is being used wisely. This is, however, less likely if a framework agreement is being used that has a number of providers, and therefore there may be less opportunity for repeat business with the same supplier. It is likely that parties will get the most out of this where it's a bespoke framework that the client has procured for their own projects, as opposed to using one run by another organisation. There may also be cost savings for a project. If a supplier has a reasonable expectation of a certain workflow from the framework, then the prices secured under the framework may be lower than those achievable in the open marketplace, and therefore should be better value for the client. That's where a general framework procured commercially might be able to procure better prices than a client's bespoke framework, depending on the work that the client can forecast will go through the framework. However, that may depend on the pricing information and the rates that are detailed within the pricing documents that form part of the framework agreement, and how it is agreed that an individual project is going to be priced. So what are the disadvantages? There is an upfront investment of time and cost in setting up the framework, and that's probably the reason that many parties don't establish their own frameworks for use on their construction programmes, but use national frameworks that have been set up by specialist organisations. That time and cost is internal admin time. There might be additional consultants that are consulted and appointed by the client in order to consider what should be included within the framework. And of course, there are likely to be legal costs as well. Now, there was an SPPN issued in 2017 by the Scottish Government that warned about the risk of using speculative frameworks. We don't have time to consider that in detail this morning, but just a note of warning that even if you're procuring a framework, from a framework, then if you're a public sector organisation, you do need to satisfy yourselves that that framework itself has been procured in accordance with procurement regulations. And the SBPN defined a speculative framework as one where the framework agreement had been awarded without prior consultation with authorities who were going to be using it, and it may have been established without any real understanding of the authority's actual requirements. Now, a disadvantage of such frameworks is that they may not cater for the client's specific requirements, and there's little scope to amend the terms and conditions. For projects procured using an existing national framework, there can sometimes be a reasonable amount of time expended using lawyers, usually, considering whether additional terms and conditions are permitted changes, both in terms of the procurement regulations and also any additional requirements that the individual framework may state. Therefore, as a reminder, before deciding to use a framework, it is important to consider the terms and conditions that will be included within the call-off contract. Do these reflect your required risk profile? Do they, for example, require that performance security is provided in respect of a call-off contract, for example, a bond? And Claire will explain shortly why such documents might be required for the project. If a party procures their own framework agreement, it may be you can include within that a parent company guarantee will be granted that covers all call-offs let under that framework agreement. Or do the terms and conditions include any limitations of liability or exclusions of liability? They probably will, and whilst we don't have time to cover that today, we have mentioned in other webinars about the fact that the market has changed and it is fairly standard now for the contract to include a limitation of liability. But is it at an acceptable level? Are you comfortable with the covenant of the supplier or suppliers who may be awarded the call-off contract? If you're using a national framework, then you won't have carried out that due diligence yourself. If you've set up your own framework, then you can ensure that any turnover or other financial requirements are met and include warranties such that the supplier would require to tell you if these were no longer accurate. One of the advantages of an organisation setting up their own framework is that they can consult with the various stakeholders and craft terms and conditions that meet their requirements and will achieve their aims. Those are therefore less likely to require further amendment later on. As we've said, that engagement does take time. If a framework is being used for both the building contracts and appointments, these might not be from the same framework provider, and therefore they may not gel unless it's a bespoke framework agreement, which should have been drafted in order that the contracts knit together. I've seen projects where there clearly has been a bit of framework shopping to procure the parties that the client wants to use for the project, and that does tend to result in a mismatch of contractual terms. So using a framework is one way of contracting and involves a formal written agreement. But going back to basics, why enter into a formal contract at all? The next slide, please. So I'm thinking here of the situation where the client has issued tender documentation to the contractor and the contractor has then submitted their tender. There may be a bit of back and forth while some final terms are negotiated. Maybe there's some revisions of some documents, and then the client accepts the tender, usually in writing, and the contractor commences work. There are no particular formalities under Scots law for the building contract to be constituted. It doesn't even need to be in writing. So long as it meets the requirements for the contract generally, i.e. agreement on the key terms, which for the construction contract are usually held to be, firstly, the parties, the works, the price, and the time for completion. And the latter two may well be satisfied if there's an adequate mechanism for determining those. Then you will have a contract in place. When I refer to a formal contract, I'm really speaking about the next step of, for example, completing an SBCC form. Other forms of contract are available, with details of the parties, contract sums, date for completion, any liquidated damages, etc., annexing your schedule of amendments and the technical documentation, all to form one contract. So why do we recommend that step? There are a few reasons. ensuring all the details are included, clarity of terms and conditions, and enforcement. It may seem obvious, but from a practical perspective, if you have to complete an SBCC form or similar document, then that ensures that all of the required information is included. At the time a tender was submitted, details like the completion date may not have been stated in any of the documents. There are several examples I can think of over the years where the client's accepted a tender and a formal contract hasn't been entered into. It's then become apparent that some details, such as the completion date, weren't agreed upon or finalised. The completion of an SBCC form or similar is therefore a good double-checking device that all of the required points are agreed. It's a similar point in relation to the clarification of terms and conditions, and that especially relates to matters such as schedules of derogations. When one has, for example, tender documents that have been issued, and then the contractor submits a tender with some qualifications in relation to the terms and conditions or the specification, they may be specific to a relevant clause, or they might just generally be included within a schedule of derogations, and it might not be clear what the final agreed position is, especially if there's been back and forth in relation to particular terms. Some of the points may well have been superseded, but will that be clear from the correspondence? And even if you can finally work that out, how long does it take to track that through? And worst case scenario, it may turn out that it's not clear that there's an agreement in place, and there might be an argument that the last document that was issued prior to the works commencing may be deemed to be the prevailing position. This also relates to associated documents like collateral warranties. If they're attached to the building contract, it's very clear what form is agreed. From an enforcement perspective, i.e. if you're going to raise a claim against a contractor, it's more straightforward for your solicitor to consider one fully executed building contract than have to trail through various attachments, or indeed for you to have to dig through files to pull out the relevant tender documents. So I'll now pass over to Claire, who's going to consider development agreements and some thoughts around performance security.
Okay, thanks, Kirsteen. Morning, everybody. In this part of the session, I'm going to look at development agreements. Can you just move on to the next slide, please? Oh, yeah, okay. Oh, no, sorry, the one before. Sorry, that's my fault. I'm going to look at development agreements as a way for RSLs to contract for works and some pitfalls to avoid by highlighting some typical provisions that parties should consider. So firstly, development agreements, the term covers a wide range of legal agreements, but the essence is an obligation on the developer to procure construction works on behalf of the other party. Typically, there'll be a transfer of interest in property, usually a sale of land, sometimes a long lease. In the house building sector, reference to a development agreement is typically used to refer to the scenario where a developer has identified a site for redevelopment, enters into an agreement with a purchaser, such as a registered social landlord, an RSL, or a local authority who will then provide housing on that site. The developer may own the site already or have an option to purchase it from a third party, and the developer will agree terms to sell the site to the RSL and build housing at the site for the RSL. Now, the development agreement may stipulate that upon sale of the site to the RSL will enter into a separate pre-agreed form of building contract, as Kirsteen's just discussed, for the construction of the works. But alternatively, the development agreement could in itself set out the developer's obligations in terms of construction of the works. There may be an expectation that that developer will step down some of those construction obligations to third parties, for example, subcontractors or professional team members such as architects and engineers. However, the developer is often a contractor in their own right and will have capacity to act as a main contractor. And so the development agreement in that scenario is essentially a purchase contract and a building contract rolled into one. Some development agreements will often reflect the so-called golden brick arrangements, and this is an arrangement which structures the sale of the land to mitigate the VAT exposure to both parties. So for this part of the seminar, we're going to look at development agreements that cover both the purchase of the site and the design and construction obligations So in this instance, where the RSL does not enter into a separate build contract with the developer. If you can move the slide on, please. So when I talk about key terms in development agreements, what I'm meaning here are the key construction terms. As I mentioned, development agreements will often cover both property transfer terms and construction obligations, so we're focusing on the construction obligations today. Each development agreement will be specific, and we are used to drafting very bespoke arrangements for clients. No one development agreement is ever the same as the one we've done before. But I've set out on this slide the so-called kind of big four construction type provisions that we would expect to be included in every development agreement. Now, it's worth noting at the outset that when parties are entering into a bespoke form of agreement, rather than using a pre-existing framework or a standard form building contract, the pitfalls are often found in what terms are actually missing from the agreement. Provisions that are not included at the outset can be more detrimental to the RSL than negotiating the terms that are proposed by the developer in the first place. So that's worth bearing in mind. So firstly, looking at quality, what is being designed and constructed and what is the standard expected. This is where a set of technical documents would usually be agreed and appended to the development agreement as a benchmark of what is required. The RSL will likely want to be able to inspect and sign off the works at completion, or at least have some input or recourse to a third-party dispute resolution process where the RSL is not satisfied that the works have been completed in accordance with the requirements. There may be an initial inspection and sign-off process if there is a golden brick arrangement to ensure that those golden brick requirements have been met before the site is sold to the RSL. It would be imprudent to include a detailed prescribed list of handover requirements, which can act as a checklist for both parties and a precondition to the developer achieving and meeting a handover deadline. And given the housing units built will likely be occupied during the sort of 12 or sometimes 24-month period immediately after handover, a detailed defects rectification protocol should also be included in the development agreement, so both parties are clear on their obligations in terms of response times for rectifying any defects, and also the process for accessing properties which are occupied by residents to fix any snagging or defects. In terms of time, when will the housing be ready? Will it be handed over in phases or all at once? There will usually be target dates and an ultimate long stop date for the works to be completed included in the development agreement. Developers will be keen to ensure that there is some flex in these dates for unforeseen circumstances, and so it would be prudent to include extension of time provisions in a prescribed list of circumstances within the development agreement. And that's particularly so that the RSL is not left in a situation that, due to, for example, its own default, time becomes what we call at large, and the developer is entitled to an objectively fair and reasonable time to complete their works. Where target dates are set in the development agreement, but they are then missed, there may be predetermined or liquidated payments to compensate the RSL, for example, for loss of rental income. And if there's an ultimate long stop date and that is missed, what is the remedy for the RSL, and is that adequate? Often termination is the ultimate remedy, but does the RSL have sufficient recourse in that scenario to be kept whole? Looking at cost, the development agreement will set out the price payable for the construction works and the basis of that price, whether it's lump sum, remeasurable, etc. There'll usually be a mechanism to allow the RSL to request any variations during the course of the works, and a mechanism to decide how the cost increases related to variations will be paid for. Even lump sum or so-called fixed price contracts for works will often provide some financial relief for unforeseen risks or loss and expense associated with unforeseeable delays to the works. So again, the RSL should be clear in what circumstances the price can fluctuate, set out in the development agreement, and ensure it has adequate contingency to cover them. Now, finally, recourse is an issue which I'm going to focus on in the next few slides. That can cover insurance arrangements, rectification of defects, the provision of collateral warranties, performance bonds, parent company guarantees, and these should usually be catered for in the development agreement. The developer might seek a provision that its liability for the construction works is extinguished at a defined point, for example, after the defect's liability period of 12 months. Now, that would likely only ever be acceptable to an RSL where it had an ongoing recourse for any latent defects that may arise in the works against the builder and the designers and the subcontractors potentially, and that would be via a full suite of collateral warranties. But where the developer is itself the main contractor, which is often the case, then that would not typically be acceptable, because the RSL would want to be in a position where it had typically a 12-year period after completion of the works, during which claims for latent defects in the works can be made against the developer. Usually a home warranty will be provided in respect of the units built, for example, NHBC or Premier Guarantee, and that is a very important part of the recourse package, but it can be limited in the types of losses that it will cover. Next slide, please. So the types of recourse I just outlined all need to be provided for in the development agreement. Now, some of these provide recourse during the construction period, such as performance bonds, cash retentions, and others provide recourse after handover, but in the event a latent defect occurs in the properties that have been built. So I'm going to look briefly at performance security, which is typically in place for during the construction period, and then collateral warranties, which provide for further reliance after the handover. Next slide, please. So in terms of performance security, I'm going to look very briefly at bonds, parent company guarantees, and cash retention. So a performance bond is a financial guarantee commonly used as a means of ensuring an RSL against the risk of developer defaulting on any of its obligations under the development agreement or becoming insolvent during the construction period. The surety or guarantor who provides the bond is an independent financial institution, often a bank or an insurance company, and the amount of security provided for under the bond is typically around 10% of the value of the construction works. Bonds will be in place for the duration of the works, typically expiring at practical completion or in some cases at the end of the defects rectification period. And in response to a valid claim under the bond, the guarantor will reimburse the RSL for their losses and expenses arising from the developer's default up to the stated value. And this reimbursement can enable the RSL to overcome any difficulties that have been caused by the non-performance or insolvency of the developer, such as the added costs that it may incur in finding a new contractor to complete the works. A parent company guarantee, or PCG, if sought, will usually be provided by the developer's parent company or ultimate holding company, and it will be in favour of the RSL. If the developer is in default of the development agreement, the RSL can call upon the parent company to remedy the breach, complete the works, or pay damages sustained by the RSL caused by the developer's breach, or it could be a combination of these depending on the drafting within the PCG. There is no industry standard form of parent company guarantee, and the drafting of the parent company guarantee and the protection that it will offer the RSL does vary from case to case. Finally, retention is another form of security that can help the RSL with recourse for developer breaches during the carrying out of the works. Retention is a fixed percentage retained from each interim payment that's made to the developer. Usually half of this is repaid at practical completion and the other half at the end of the defects period. And it does act as an incentivization for the developer to complete the works and return to fix any defects within that defects rectification period of 12 or sometimes 24 months after handover. It's important to ensure the drafting and the development agreement expressly permits the RSL to use the retention if it requires to use the retention because the developer has defaulted in not returning to fix defects. So usually one or more of these forms of performance security will provide the RSL with some comfort in the event of developer default or insolvency during the carrying out of the works. Next slide, please. What I've done on this slide is just set out the difference between the two main types of bonds that are available for construction works. And I say these bonds are available, but what we are finding with both conditional and certainly on-demand bonds is they are becoming less and less available in the market. So the two types of bonds, performance bonds that that are or were available are so-called on-demand bonds and conditional bonds. An on-demand bond can be called at any time by the beneficiary of the bond, and the surety or the guarantor who has given the bond is obliged to pay on demand on receipt of a simple demand notice. The RSL in that scenario does not have to demonstrate it suffered a loss at the time it issues the demand notice. And so on-demand bonds provide instant, easily accessible redress to RSLs. Therefore, unsurprisingly, they are less readily available and very expensive to procure. Because provided the procedural requirements for making a demand under the bond are met, there's little scope for the developer or the grantor of the bond to challenge the demand. Conditional bonds, such as the Association of British Insurers, that's the ABI model form of bond, oblige the surety or the guarantor who's granted the bond to reimburse the RSL, provided certain conditions have been met. Now, usually these conditions would be the developer's insolvency or breach of contract. However, in order to call upon the bond, the RSL has to first establish default by the developer, in this case, default of the development agreement, and also ascertain what its losses are as a result of that. Now, establishing default is often achieved by obtaining a judgment from a court or an adjudicator's decision evidencing breach of the underlying development agreement and a note of the loss suffered by the employer as a consequence of this. So where there is a developer insolvency, a conditional bond does not necessarily provide that immediate cash flow to the RSL to complete the works, because the RSL has quite a few hoops to jump through before it can actually make a call on the bond and get its hands on the money that the bond will provide. However, the overriding benefit of a performance bond to an RSL is that it does have that monetary guarantee, and it's provided by a third-party surety whose financial covenant is not linked to the developer, and it's very much a sort of standalone institution. Next slide, please. I've put on this slide just a few issues we're currently seeing with procuring bonds and parent company guarantees in the current market. Agreeing the terms of and obtaining a bond or a parent company guarantee is certainly not without its challenges at the moment, and we're certainly experiencing what we describe as the so-called hardening of the bond market, where bonds are increasingly difficult to obtain. Interestingly, contractor insolvency under an SBCC form of contract is not an automatic breach of contract. So if you are using a development agreement, you should make sure that it does include provisions that set out what the RSL's options are in the event of developer insolvency, and be clear if this breach automatically entitles the RSL to terminate the development agreement. For a call to be made on a conditional bond, as I've just mentioned, in the event of developer insolvency, the RSL might need to terminate the development agreement on the grounds of insolvency, complete the works using another contractor, and then establish what its additional losses are incurred in doing so before it can make a call under the bond. Bond providers are now taking more of an interest in the expiry date of the bond. So historically, the expiry date of the bond was always linked to the term practical completion and when that was achieved. But what we're finding now is often bond providers are looking for a long stop date to be written into the bond. So if there are delays to the works, the bond might well expire before practical completion has actually been achieved under the development agreement. So in that scenario, do be aware, because if you know that the bond is going to have an ultimate long stop date in it, you can cater for that scenario in the development agreement, for example, by permitting the RSL to withhold a greater sum of retention at the point if the bond falls away before the works have reached practical completion, to provide an alternative remedy. We're also increasingly finding that parent companies or ultimate holding companies are less likely to grant what we would have considered to be a typical parent company guarantee. And they're looking for parent company guarantees to contain limitations on their liability, such as an expiry date under the parent company guarantee and financial caps on the amount that they're prepared to guarantee. Of course, parent company guarantees are only as good as the covenant of the grantor, and so there's also the risk that if the developer becomes insolvent, its parent company may also become insolvent. Next slide, please. So as I've mentioned, the difficulty and expense in procuring bonds has led to an uptick in different options around retention being explored. Increased retention in lieu of a bond can benefit both parties, and we're increasingly seeing parties becoming more creative with the retention provisions that they put in their contracts or development agreements in order to provide that security during the construction phase without the expense of procuring a bond. We have seen some cash retentions of up to, for example, 10% of the contract sum being agreed in lieu of a bond, but often with a proviso that that percentage will ramp down to a more typical level of, for example, 5% as the works progress towards completion and the risk to the RSL decreases. Now, bespoke drafting can cater for this in the development agreement. Next slide, please. So I've just sort of covered bonds, parent company guarantees and retention, which provide recourse during the construction period. But what about after handover? A robust set of collateral warranties can provide a good second layer of protection to an RSL in the event of any latent defects in the works that occur after handover, where the developer would usually be the first point of contact for any claim in accordance with the terms of the development agreement. In the event of developer insolvency, collateral warranties can plug the gap left by the developer's absence. Next slide, please. So collateral warranties, what are they, why do we need them, and who are they granted from? Well, a collateral warranty is a contract that is collateral to an underlying contract. So it's collateral, for example, to a subcontract entered into between the developer and subcontractor, or it could be collateral to a designer appointment entered into between the developer and, say, his engineer or architect. Why do we need them? As I said, they provide the RSL with a right of recourse that it would not otherwise have against these third parties, subcontractors, or professional team members who the RSL is not in itself in contract with. And they give that second layer of protection in addition to the obligations of the developer under the development agreement. And who typically grants collateral warranties? As I've said, they're from third parties such as subcontractors and designers who have carried out some of the design and or construction of the works, and they would typically be granted in favour of the RSL. Next slide, please. Thank you. I've set out on this slide some key provisions that are usually contained within the collateral warranty. Briefly, these are confirmation and undertaking that the person who's granting the collateral warranty has complied with the underlying contract, be that the subcontractor appointment agreement. There's usually a typical duty of care provision. The grantor of the warranty will be obliged to maintain professional indemnity insurance at a specific level for a set number of years. There'll usually be an undertaking in the warranty that the grantor of the warranty hasn't specified for use in the works any prohibited materials. They will usually give the beneficiary, i.e. the RSL, a copyright license to use any plans that they've prepared in connection with their appointment. There might be step-in rights for the RSL. The RSL will usually be entitled to assign the warranty to a third party. So if the RSL sells on the housing to another party, they can transfer the benefit of all the collateral warranties to whoever they sell the completed units to. And there'll also be things like limitations of liability, etc., that might also be covered in the collateral warranty. Next slide, please. So, as you've hopefully gathered from this part of the session, unlike pre-agreed frameworks or standard form building contracts, there's no set terms for the construction provisions within a development agreement. And the pitfalls in terms of the construction obligations and liabilities are often around drafting that's missing from the development agreement rather than the negotiation of the terms that are proposed at the outset by the developer. So I've set out in this last slide some drafting tips to cover those recourse points, which I've covered today. So firstly, you would want to ensure in your development agreement there's an obligation on the developer to procure collateral warranties from key third parties, to provide a bond if that's been agreed at a commercial level, or a parent company guarantee. It would be useful in the development agreement to have an express, tangible sanction for non-compliance with this. So for example, a financial penalty until these items are delivered, or the condition that practical completion cannot occur until a full set of collateral warranties have been delivered to the RSL, for example. Because collateral warranties are collateral to the underlying contract and backed up by professional indemnity insurance, there should be obligations in the development agreement that the developer will provide copies of those underlying contracts as well as the collateral warranties and evidence of the professional indemnity insurance maintained by those third parties. And that will give the RSL the full pack of documents so that if it ever has to make a claim under the collateral warranties, it's got all the information it needs to do so. Agreeing the form of words of the collateral warranty, the form of words of the bond, and the parent company guarantee is very important as well, because the terms of those ancillary documents will dictate how valuable or not valuable they are for the RSL. So as part of the negotiation of the development agreement, it's important to include templates of these ancillary documents in pre-agreed terms that you want the developer to procure. So there can be no discussion after the fact on what the terms of the bonds are, what the terms of the parent company guarantee is, or the collateral warranties. And if you are going to have a retention, there should be express provisions within the development agreement regarding use of that retention money by the RSL where the developer fails to turn up and rectify defects. So you might, for example, have a notification provision whereby if the developer fails to rectify the defects within X period, the RSL is entitled to rectify those defects itself and deduct the cost of doing so from the retention pot that would otherwise be payable back to the developer. So that brings this part of today's session to an end. I hope you found it useful. Kirsteen and I are happy to take questions or follow up separately with anyone who has any queries.
Thank you very much, Claire and Kirsteen. I'm conscious of time, so I think probably we have time for one question, then we can follow up with some others afterwards. Kirsteen, you mentioned caps on liability. Whilst I appreciate that wasn't the main topic of today, are you able to provide some information on what you're seeing within the market at the moment?
Yes, yeah, no, absolutely. So yes, as I said, caps on liability are a lot more common than they were, even just several years ago. And I think that's probably been driven by a number of the things. So Claire mentioned the hardening of the bond market, the hardening of the insurance market is also a very big issue for parties. I think it's probably been a bit more of a contractors market at times. We know that contractors are being selective about different projects. And I think because NEC has become a lot more prevalent and it includes within it X18, then although it's an option, it's tended to be included now. So I think there's probably just a bit more of an expectation now that some sort of cap and liability will be included. Now, what exactly that cap is, i.e. what level that cap's at, and what might be excluded items from that cap, it is often quite a detailed negotiation between the parties, and linked to that is, what insurances are in place, because if a party's got insurance to pay out for something, then it's natural that the client would want to get the benefit of that. One thing to note, just out of interest, is that so the JCT have just recently released 2022 forms, and one of the things that people had wondered was, would they include a cap and liability within their draft contracts? And there's as in an overall cap and liability, and they've not. And the reason they gave for not including that cap and liability was that given that the JCT contracts, and the sort of same can be said for the SBCC contracts that are used in Scotland, because they're used for a wide range of projects and across different sectors, they didn't consider it was market to include those. So I think there is still, there's still potential to be pushing back on that, but certainly I think commercially people are much more likely to be taking a view on that than they would in the past.
Excellent. Thank you very much.
I don't know if you've got anything else to add to that, Claire.
No.
Okay, well, I think I'm conscious that sounds bang on 12:15. So we will bring this session to an end. All that remains for me to say this time is thank you very much for joining us this morning, near the afternoon. We do hope you found the session useful. If you have any questions that spring to mind over the coming days or weeks, then please contact Kirsteen or Claire. So thank you very much for joining, and hope you enjoy the rest of your day.
Thank you.
Thank you.